Thank you very much, and thank you also for the Icelandic authorities and the Council of Europe for that invitation, for having organized that conference on this subject. Trying to present the framework on the fight against sexual exploitation of children and sexual abuse is, of course, a very difficult exercise. I realize that there are many people in this room, and I've been aware of also. I've been informed that there was also members of judicial authorities here in Iceland, and it is for that reason something which is also very important for me. To talk to colleagues, to talk to judges especially, because we all know that we have a requirement along the line of the independence of a judiciary, but it is also very important for judges to be involved in development and reflection along this line, because when the convention is ratified by a country, when it becomes part of the national legislation, and it has also to be implemented by the judge, even if it does also need some implementing legislation from the parliament. So for me, it is very important to know that there are also judges and prosecutors in this room to talk about this subject. It's a very difficult issue to try to talk about sexual violence against children and an international framework on this issue, just because it's it's not only a very difficult issue, it's also an issue which is very broad. And to have some minutes in order to explain what is the international framework is really a challenge. I haven't prepared any PowerPoint presentation, so you will have to listen to me in my bad English. I'm sorry for that, but anyway, I hope I will be able to do it. If I try to present the international framework, I should start to say that at the international level, not the level of the Council of Europe, but in an international level, there are only few instruments dealing with that issue. We can mention, of course, the Convention on the Protection of, the United Nations Convention on the Right of Child and its optional protocol, and we can mention also the International Labour Organization Convention concerning the prohibition and immediate action for the elimination of worst form of child labour. But these instruments are constructed in very broad terms and do not cover comprehensively all the issues of sexual exploitation and sexual abuse of children. In the same time, we had few international congress and political commitments which were taken in order to fight against this issue. And at the European level, the Council of Europe played a very great role in preparing this congress and also in monitoring the implementation of a commitment taken during this congress. In the same time, also, the Council of Europe adopted several instruments which contains provisions covering partly the issue of sexual abuse against children. I should mention the European Social Charter, the Convention on Cybercrime, and the Convention against Trafficking in Human Beings. But when talking specifically to fight against sexual abuse and sexual exploitation of children, the first instrument that I have to mention is a recommendation on the protection of children against sexual exploitation, which was adopted in 2001. But of course it remains a soft law instrument. So the political commitments and the work of the Council of Europe came to the conclusion that there was a place for and also a necessity of a new binding instrument on this issue. And this is the reason why the Committee of Ministers adopted terms of reference which lead to the Lanzarote Convention adopted in 2007. I would present firstly the main characters in that convention, then I will go to the provisions on substantive criminal law, which are quite important, and after that I would present, if I have time enough, all the provisions of the convention, but in very broad terms, because the convention is 50 articles, so it would be impossible to present all the entire text of the convention in 10 minutes. The main characters of the Lanzarote Convention are the following one. The first one is that it's a comprehensive instrument. It covers all the aspects of a fight against sexual violence and sexual exploitation of children. I should add that it covers preventive measures, or it contains preventive measures, protective measures and assistance to victims, international intervention programs or measures, substantive criminal law, investigation, prosecution and procedural law, and provisions as well on recording and storing of data and international cooperation. The second point I should mention is that the Convention covers any person under the age of 18 years and is not limited to acts committed for commercial aims. The first main character is that it's a flexible instrument. If you read the Convention, you will see many provisions in which we had the words in conformity with its internal law. This has been done in order to allow the state party to implement the convention in a way which is in accordance with the basic principle of the law. The convention mainly defines objective, but leaves to the party to decide how to achieve this goal. It's also the reason why there are several provisions allowing for reservation in the Convention. Of course, it will be one of the tasks of the monitoring mechanism to examine that reservation and the possibility for the state party to lift this reservation. The last character, but not the less important, is that the Convention provides for a special monitoring mechanism, which is based on the Committee of the Party. The Committee of the Party has a task to monitor the implementation of the Convention, but also, and this is very important, to act as a center for the collection, analysis and sharing of information, experiences and good practices. I would then now come to the provisions relating to substantive criminal law. The Convention contains a lot of provisions on this issue. The first one relates to sexual abuse, and the Convention defines two types of sexual abuse. The first one is the fact of engaging in sexual activities with a child who has not reached the age defined in domestic law, below which it is prohibited to engage in sexual activities with him or her. The second one, is engaging in sexual activities with a child, regardless of his age, where use is made of coercion, force, or threat, or when the person abuses a recognized position of trust, authority, or influence over the child, or where abuse is made of particularly vulnerable situation of a child. I should we should notice that the Convention does not harmonize the age below which it is prohibited to engage in sexual activities with a child, due to the fact that there are many differences between the member states of the Council of Europe. It goes to 13 to 16 years old, more or less. Sexual activities is not also defined in the Convention, and the Convention leaves to the member states, the state parties, to define the meaning and the scope of these terms. The Convention also does not intend to criminalize sexual activities of young adolescents between them. And I have to mention that according to the European Court of Human Rights, reference to coercion, force, or threats requires criminalization of any non-consensual sexual act, including in the absence of physical resistance by the victim. This is something which has been set up in the decisions of 2003. I will not go into too much detail, but during the discussion, if there are questions about, for instance, what is recognized as a position of trust, authority, or influence of a situation of particularly vulnerable situation, we can also answer your question on that. The second type of offense, which is set up by the Convention, is offenses concerning child prostitution. Certain conduct related to child prostitution have to be criminalized according to the Convention. It includes recruitment, coercion of a child to participate in prostitution, and recourse to child prostitution, between more or less use of sexual services. The Convention also requires state parties to criminalize offenses relating to child pornography. This covers the production of child pornography, the offering or making available of child pornography, distribution or transmission of child pornography, procuring and possession of child pornography. A new offense has also been introduced in the Convention, which is very important because it is the first one, the first instrument to have such a provision in it. It's the intentional access to child pornography. This provision is intended to cover a situation where someone watched child pornography online by accessing by accessing child pornography sites, but without downloading the images, which would imply possessing. So the state parties have also to criminalize the intentional access to child pornography. The Convention also requires state party to criminalize certain acts in relation to participation of a child in pornographic performances. It covers the organizing, assisting to pornographic performances. It also requires to the criminalization of corruption of children, which is the fact of causing a child below the age for sexual activities to witness sex abuse or other children or abuse or sexual activities. The Convention also contains a new provision relating to the criminalization of solicitation for children for sexual purpose, which is a new offense. These provisions require to criminalize the intentional proposal of an adult to meet a child below the age for sexual relation for the purpose of committing sexual abuse through the use of information and communication technologies, and when such a proposal has been followed by material act leading to such a meeting. I would stop with the provisions on criminal aspect. We have in the Convention other provisions covering, for instance, the issue of jurisdiction, aggravating circumstances, and so on. But if you have questions, that we can answer that during the discussion. The other provisions relate to preventive measures. They cover recruitment, training, and awareness raising of persons working in contact with children, the education of children, the promoting or conducting awareness raising campaign, preventing or prohibiting advertisement of the offences, encouraging information and technology sector to participate, as well as involving the NGOs. So I will not also go into details because the Convention is very, very detailed with its regarding this kind of provision. I will not cover also the intervention program and measures, but you should know that the Convention, for the first time, because it's the first instrument to do so, contain measures targeting sex offenders, focusing on medical and psychosocial aspects of the intervention program of measures offered to sex offenders, but it's based mainly on the non-obligatory character of this intervention. Sorry. I will not cover investigation, prosecution, and procedural law because this is Turkovic will talk about this aspect of the question when talking about the guidelines. And in order to finish my speech, I should say also that the Convention contains provisions which are more or less detailed ones regarding the collection of data, exchange of data, and international cooperation in criminal matters. I would finish by this. The speech I prepared normally contains more detailed explanations, so if it's been distributed or anyway published after that by the Council of Europe, you will find more detailed development on this issue. And of course, I'm open to answer your questions during the discussions after that. Thanks a lot.